Okay.
Jefferson County Code Law number 2 is in session. The court is in session. The cause number M325512. The case is styled the state of Texas versus Jairus Lynn Botley. Mr. Botley, is that your full name?
Yes, sir.
Mr. Botley, would you please raise your right hand? Mr. Botley, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Botley? That's good. Now, Mr. Botley, you're representing your case by your attorney Marshall Norman. Attorney Norman, how are you doing?
That's fine.
Attorney Norman, do you waive a record in Mr. Botley's case?
We do.
State is represented by Attorney Ray Shearer. Attorney Shearer, how are you doing?
Doing good, Your Honor.
Okay, Mr. Botley, in cause number M325512, I have before me an information. This information alleges that you, Jairus Lynn Botley, on or about April 2nd of 2019, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Botley, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Botley, how do you plead? Guilty, not guilty, and no contest?
Yes, sir.
Now, are you pleading
No
guilty?
contest, Your Honor.
It's no contest?
Yes.
Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Botley, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishments, also labeled State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there's a set of initials, JB on a line next to a box that's checked, no continuous means no contest. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
On the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? There is one box that's checked at the top of this document. That box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Mr. Botley, before you signed and initialed these documents that I just showed you, did your attorney go over these documents with you?
Yes,
And did you read and understand everything that she went over?
yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Mr. Botley, are you a citizen of the United States?
Yes,
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment, and State's Exhibit Number 2, the probable cause affidavit, which is in the court's file. State, you like to offer States 1 and 2?
Straight with Your Honor.
No objection.
No objection. State's Exhibits 1 and 2 are admitted. Ms. Norman, you've advised and counsel Mr. Botley. Is there any evidence that he's currently mentally incompetent to stand trial?
No.
Mr. Botley, the attorney, Ms. Norman, has advised and counseled you. Are you satisfied with the representation? Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Botley, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor, we do.
And what is that agreement?
The agreement is for Mr. Botley to serve 30 days in the Jefferson County Jail. He has credit for that time served, so this is a credit for time served case. And we're also asking that the court costs be taxed and returned.
Okay, Mr. Botley, the state is offering that you serve 30 days in Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 30 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court cost in this case is $392, but you would not be required to pay the $392 court cost because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Botley, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Mr. Botley, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Botley, you're gonna stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, then you'll follow the directions of our bailiff. And Mr. Botley, this will conclude your case. And you have a blessed day. Ms. Norman, you have a blessed day as well.
Mr. Crowley, can I get your right thumbs read 3 times on this piece of truck? Got it?
Hey.
Are you here about the what?
Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to County Court at Law Number 2 today because you have a case in County Court at Law Number 2. The case that you have in County Court at Law Number 2 is a criminal case. Criminal cases are divided into felonies or misdemeanors. Felony cases are normally referred to as your most serious type offenses, and your misdemeanor cases are normally referred to as your petty offenses. It doesn't mean that they're not serious. It just means that they are not as serious as a felony offense. And when I use the term serious, what I'm talking about is the nature of the offense and the punishment that a person can get or receive from being convicted of a criminal offense. Felonies are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If you're convicted of a state jail felony, the range of punishment is minimum of 2 years to maximum, a minimum of 6 months to a maximum of 2 years in the state jail, a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment minimum 2 years to maximum 3 years, and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is a minimum of 2 years to a maximum of 20 years, and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is a minimum of 5 years to a maximum of 99 years to life in the state penitentiary, and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is life in the state penitentiary without parole or death by lethal injection. Now, the offense that you have in this court, as I mentioned earlier, is a misdemeanor case. Misdemeanors are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is by a fine only. You only can be given a fine, you cannot be given jail time. However, if you fail to pay the fine, then the court can convert your fine to community service. And if you fail to pay the community service or perform the community service or pay the fine, then a capious pro fine can be issued for your arrest. And what that basically means is a warrant that is issued for your arrest for you to either pay the fine or sit out the jail time to pay off the fine. Now, if you're convicted of a Class B misdemeanor, the range of punishment is minimum 0 days to maximum 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to 365 days, which is a year in the county jail, up to a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights, and one of the rights that you have is on the paperwork that has been handed out on the clipboard. First right that we're going to talk about is your right to have an attorney. On the clipboard, the first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. And it states as follows: as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may waive your right to an attorney and you may represent yourself. Waiving your right means you're giving up your right. So you may give up your right to have an attorney to represent you, and you can represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date from today. Your case will be reset to give you time to hire an attorney. If you want an attorney and do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Now, you would have to first fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to an attorney, or if you want to give up your right to an attorney and represent yourself, you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to have an attorney to represent you. Now, the document on the clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial, that's the form that you would have to fill out. First, you would have to read it and sign it. And I'll go over that with you after I go over this form, after I finish going over this form. The next paragraph says, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including worse outcome for you and your case, including the loss of significant legal rights and opportunities related to military service, housing and public benefits, child custody, military service, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, you can change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that document, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left. If your choice is, well, if you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to see if you qualify for a court-appointed attorney, then you'll put your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is to waive your right to an attorney or to give up your right to an attorney and to represent yourself, then you'll place your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, then you will sign your name on the line that is titled defendant. You will also sign today's date on the line that is titled date. And today's date is June 20th of 2023. The next document is for those individuals who will be waiving their rights to an attorney and representing themselves. That document is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 20th day of June 2023 by County Court Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, June 20th of 2023. Now, as I mentioned earlier, you also have other rights besides your right to have an attorney. One other right that you have is the right to have a trial by jury. Where those young people are sitting in that area over there, we call that the jury box. And the jury box, that's where 6 citizens who will be selected to sit as jurors on your case, they will sit over in that area. They will listen to all of the evidence. After listening to the evidence, they will deliberate and they will decide whether to find you not guilty or guilty. You also have a right to waive, which means to give up your right to have a trial by jury. And if you waive or give up the right to have a trial by jury, you will not be having a trial by jury. Now, your case will come before the court or before the judge in one of 3 ways if you waive your right to have a trial by jury. One way that your case will come before the court is by way of a trial. We call that a bench trial. And what a bench trial is, you will be having a trial before a judge only. You will not be having a jury because you waive your right to jury trial, but you want a trial. So the trial will be before a judge only. The judge will listen to all the evidence. After listening to all the evidence, the judge will decide to find you not guilty or guilty. You also have your case will also or can also come before the court by way of an agreed plea bargain agreement. And what that basically means is you and the district attorney's office has reached an agreement to settle your case. Now, for example, the state may offer you, let's say you spent 5 days in jail, and the state offered you 5 days in jail, and you say, well, I accept that plea bargain agreement. Now, what that basically means is your case will come before the court. The court will have to decide whether it will accept a plea bargain agreement or reject the plea bargain agreement. Now, if you serve 5 days in jail, that just simply means that you would not have to serve any more time in the Jefferson County Jail in this case because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, the other way that your case can come before the court is by way of an unagreed plea bargain agreement. What an unagreed plea bargain agreement is, means that you and the state of Texas or the district attorney's office have not been able to reach an agreement on your case. And so you want to enter a plea of either guilty or no contest. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. If you enter a plea of no contest, you're telling the court that you will not be fighting the charges. And so if you want to enter a plea of guilty and no contest, and the case, and you want to waive your right to a jury trial, and you don't want a bench trial, you want to enter a plea, you and the state have not been able to reach an agreement, so but you want the judge or the court to decide what your punishment will be, we call that an unagreed plea bargain agreement. And your case will come before the court, and the judge will decide what the punishment will be in your case. Now, you also have a right to have witnesses to come to court. Witnesses, they can testify either for you or against you. They will sit in that chair over there with the microphone in front of it. We call that the witness stand. And as I mentioned earlier, they can testify for you, they can testify against you. If you represent yourself or if you have an attorney to represent you, you or your attorney can ask them questions. You can ask them questions if you're representing yourself. Your attorney will ask them questions if your attorney is representing you. We call that cross-examination or direct examination. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in the case that the state has against you. The state cannot force you to testify. They cannot make you testify. They cannot call you as a witness in your case because you have a Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And what that basically means, if you waive or give up your Fifth Amendment right against self-incrimination, you will be testifying in your case. Now you also have, as I mentioned earlier, you can call witnesses. Now, you also have a right to waive your right to have witnesses. Now, if you waive your right to have witnesses, that means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses because they will be calling witnesses in your case. You also have a right to just have what is called discovery. Discovery is you have a right to have access to the evidence that the state has or that the state will be using and has in your case. You have a right to see the documents. You have a right to see witness statements, your statement. You have a right to have access to the instruments, audio recordings or video recordings, whatever evidence the state has, you have a right to have access to that. Now, if you're representing if you are being represented by an attorney, your attorney will have access to the discovery. Now, as a defendant in a criminal case, you have been arrested and you're here today, as I mentioned earlier, for an arraignment. That's because you've been arrested and you're out on bond. You're either out of jail on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out on surety bond, which means that you paid a percentage of the bond to a bondsman so that the bondsman can get you out of jail, or you're out of jail on a PR bond, which is normally referred to as a personal recognizance bond. And that simply means that you did not pay anything to get out of jail. You were released under your own personal recognizance. Now, every day that you spent in jail, it can be used as credit toward your punishment. So for example, if you spent 5 days in jail, you and the state have reached an agreement to settle your case for 5 days in jail. That simply means that you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served in jail. Now, if you have reached an agreement with the state for you to serve 7 days in jail and you only serve 5, that means you have to serve 2 more days in jail because you'll be given credit for the 5 that you already served, and so you only have to serve 2. Now, every day that you spent in jail, you will receive credit at $100 per day that will go toward your fine and court costs. So if the state is offering you, if you spent 5 days in jail, that's $500. So if the state is offering you $500 of fine and court costs to settle your case, and that simply means that you will not have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. And therefore, the fine and court costs will be taxed and retired. Now, if they offer fine and court costs of $700, you spent 5 days in jail, that means you would have to pay $200. Why? Because you spent 5 days in jail, that's $500 that will go toward the $700, so that leaves $200 to be paid. Now, you'll be required to pay the $200 on the day of the plea. If you cannot pay the money on the day of the plea, or if you're unable to pay the fine, then we can convert it to community service. And by us converting it to community service, every 1 hour community service that you perform, $4.50 will go toward payment of your fine and court costs. So for example, if you perform 8 hours of community service, that's $100 that will go toward your fine and court costs. Okay? Now, Jefferson County has a program that is called pretrial diversion. With that program, pretrial diversion, if this is your first time being in trouble, you don't have a criminal history, if you do not have a criminal history, then the DA's office, if they allow you to get into the program, if they accept you into the program, your case will be dismissed, and then you can get it expunged, which means you can get it wiped off, deleted, or erased from your criminal record. And in order to get into the program, it has to be the first time that you got in trouble with the law, and you have to have an attorney to assist you at making the application, submitting the application to the district attorney's office. And it cannot be for an offense. Your offense cannot be for unlawfully carrying a weapon or resisting arrest. So if you have any other offense, first time being in trouble, you may qualify. You get into the case, they'll dismiss the case. You get into the program, they'll dismiss the case, and you can get it wiped off your criminal record. Now, Jefferson County also has another program that is called Veterans Court. And with the Veterans Court program, if you're a veteran of any one of the branches of the United States military, the program works basically the same way. You get into the program, you complete the program, they dismiss the case, and you can get it wiped off of your criminal record and get it expunged from your criminal history. And then the only requirement is to be a veteran of any one of the branches of the United States military. Now, this court, County Court of Law number 2 of Jefferson County, Texas, has a program that is called the Community Safety Initiative, or the CSI program. That program is a program that I started in March of 2017, within first 100 days of taking office. And that program is designed to address the issue of what we call recidivism. Recidivism is when people commit crimes over and over. So how do we prevent it? Well, we prevent it through the Community Safety Initiative. And with this program, our Community Safety Initiative, we have partnerships with agencies in our community. One of the partnerships that we have is with Spindletop. The people that I've introduced to, I actually pointed out to you earlier, they're with Spindletop, and they're going to come to you in a few minutes and tell you something about the program that they have to offer at Spindletop. Now, Spindletop is our local mental health center. It's the Spindletop Center. It's our local mental health center in, I guess you could say, Southeast Texas, or in the Golden Triangle. And what they will do, they will be able to address mental health issues that you may have. You don't have to be insane or incompetent. You can suffer from anxiety, depression, or a whole host of other mental health issues. They'll be able to address those. And the way they will address it is through a private interview, an assessment, and they can develop, treatment plans can be developed from an assessment, such as either outpatient or inpatient placement. Now, the other thing is, if you have problems with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery, and our local drug and alcohol council has a program that is called OZAR. OZAR stands for Outreach Screening, Assessment, and a Referral. And basically with those programs, it is a program that is designed to address drug and alcohol issues, and it's a drug and alcohol recovery program. And with those programs, they can do a screening, an assessment, and you can either get outpatient or inpatient treatment, depending on the level of your drug or alcohol addiction. Now, the other thing is, if you are unemployed, if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and chemical industry. Once you are trained in one of the areas any one of those areas that you are interested in, then they will assist you in getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get a high school diploma or a GED, well, Lamar University CICA has a GED program, and with that program, you can get your high school equivalency or the graduate equivalency diploma. All of these programs that I just mentioned to you are free. It does not cost you anything. Only thing that you have to do is take the time to participate in one or more of these programs. Now, the other thing about these programs, all of these programs can be used as community service. So for example, let's say you were given a fine and court costs, but you do not have the money to pay the fine and court costs. So we converted your fine and court costs to community service. So every hour that you're in one of these programs, 1 hour will go towards your community service, $12.50 will go toward the payment of your fine and court costs. So you're doing one thing, but you're getting credit for three things. You're in the program, that's one thing. You're paying your fine and court costs, and you're doing community service. So you're killing three birds with one stone. The other thing is, I tell people, when you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in the life. We're trying to make a difference in Jefferson County, the community or the county in which we live. And so with that being said, in county court at law number 2, we do not just give time, we take our time. And and what I mean by that is, we do not just arrest the problem, we address the problem. And we believe that by addressing the problem, we can produce productive people. And if we produce productive people will not commit crimes because they have too much to lose. So if you're interested in any one of these programs, just let us know, and we're happy to point you in the right direction. We have brochures that can be handed out with contact information so that you can be in contact with individuals that can help you to address whatever need that you need to have addressed. Now, at this time, we're going to have our folks from the Spindletop. We're going to have Deputy Hinton. We're going to have Ms. Leggington and Chris to come forward, and they're going to tell you something about the program that they have to offer at Spindletop. You're welcome.
Morning. My name is Steve Kent. I am the licensed mental health deputy. And this is my coworker Chris, as well as Gabby back here. Both of these ladies are qualified mental health professionals. The reason we are here today in Portland is because the judge cares about every single person. What the judge has found, and statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources.
So when we said mental health needs, he means like that's anxiety, depression, things that exist on a day-to-day basis that everybody lives. Being in the court process does not necessarily make these easier. In fact, like I said, the community resources, there's a lot of things that are really well funded, but they're not well advertised, and getting set up with them can be a bit of it can be a bit overwhelming sometimes. So if you're already dealing with this process and you're already a little overwhelmed, then it feels like juggling. That's kind of where we come in.
So maybe this is your first time to be here, maybe it's your 10th time to be here. There's still hope. This program actually has the ability to change your lives. But we're gonna need something from you, but we need you to share that need. Chris is gonna explain how you can do that today.
So whenever you guys came in, Gabby handed out a form that looks like this. It functions as a baseline for the consent form. The reason it's built like that is because none of your information is going to be shared outside your medical functions, just like your medical information. The only thing that this allows us to do, either me or Gabby, is going to be to contact you once in a matter of your choosing, or talk today privately if you want to. Now, if you choose for us to contact you, we'll keep contacting you as long as you reach out to us back. We'll work as hard for you as you do for yourself, and you all already showed up here. We know you work hard for yourself. Now, outside of that, if you tell us you don't want to talk, or you check in with us and you tell us, well, went okay, or I don't need anything right now. The important thing is that you have a number, so that you have a way to contact in case you do need something, or in case somebody else in your life needs something. This doesn't have to just be for you. We kind of function as a giant loophole on that, where we're meeting you in the court, but if you need information or resources for somebody else you care about, by all means, pick our brains, put us to work. That's what we're here for.
This document is separate from the court documents. The court will not receive this. We are the only ones that will receive this. This is regulated, which means it's private. It will not be shared outside of the commission. But before you leave here today, I want to give you a copy of this flyer here. On the back, it tells you a little some of the advantages of the program itself. But also on the front, there's a 1-800 number if you ever find yourself in one close. You can call that number and get what you need.
Now, what's important about that is that number is almost statewide. The reason that's important is because we know that a lot of people live in Port and Jefferson County that are not from this area. Some are not even from this area of the state. It doesn't limit our ability to find resources for you. If you need help with something, the very least we can get you set up with the people that's most appropriate in your area for that. In case, like if you break down the side of the road, you have a panic attack, or you just need somebody to talk to, you can call that number 24 hours a day, and you can reach out to them and get yourself the most affluent resource at them.
Just a little bit, the court is going to go into recess. When we do, we will be coming out to the gallery. We'll be able to speak to you privately. We'll pick up those forms, and I'll also hand this out to you at that point in time. And we'll have an opportunity, if you want to talk to Dave, the judge has given us permission to speak in his jury room privately. And we can do that today if that's something that you've seen about.
That's if you have any resources you need, and even if you need a moment to breathe. It's like we said, this is an overwhelming process. If you need space, if you just need to sit with us for a moment, we're here for that too. Overall, the big thing to take away from this is we're here to help. Anything to set you up with, anytime you work with us, it's not going to cost you anything. Resources that set you up with are going to either be sliding fee scale or state funded. We're not here to add any extra stress. We're not here to add any extra time to the court process. It's just whatever works best for you.
Thank you very much. You're very kind for listening. Thank you, Your Honor.
Okay, you're welcome. Okay, ladies and gentlemen, the paperwork that you have on the clipboards, we're going to pick that paperwork up from you, but if you need any help with the paperwork, we have our court personnel who's here to help you. Just simply raise your hand, and someone from the court will come by and assist you at filling out the paperwork. Now, it's going to take us a little time to get the paperwork from you. And if you need to go to the restroom, The restroom is right outside the courtroom, right next door in front of County Court Law number 3. And that's the male restroom. And on the opposite side of the hall, in front of the 172nd District Court, is the female restroom. So you'll be able to use the restroom. Now, do not leave the courthouse. Now, if you leave the courthouse and if we call your name and you're not here, your bond can be forfeited. If your bond is forfeited, a warrant will be issued for your arrest. So at this time, if you need some assistance, just please raise your hand and we'll have someone from our court personnel who will be happy to help you. So at this time, we're going to go into recess, and I think folks from Spindletop may come by as well.